In sentencing, the first convict was convicted of, was convicted of the offense of conspiracy to commit a crime, namely trafficking in persons, 3 counts of trafficking in persons, and 3 counts of neglect of a child. The second accused, herein convict, was convicted of 3 counts of neglect of a child. After conviction, the court was notified that the 2 convicts have no previous records of conviction. The court preferred that the 2 convicts be examined by the probation officer for pre-sentence report, and each convict presented oral submissions through the advocates for mitigation prior to sentencing. In summary, the first convict, through his 2 lawyers, submitted that he has no criminal records. He pleads with the court for non-custodial sentence. The court was reminded of the objectives of sentencing, and that is rehabilitative and restorative factor. The court was informed that the first convict is a family man with 2 young children, age between 2 years and 3 weeks old. He is a husband of 1 wife, a breadwinner who caters for his extended family. The court was notified that he lost his father at a very tender age, and now he is 1 year old and a firstborn in a family of 5. It was mentioned that his siblings, mother and stepmother, depend on him since they have no employment. In pleading with the court for non-custodial sentence, it was stated that he needs a non-custodial sentence to allow him reflect on the gravity of the just concluded trial, and also to continue supporting his family. He prays for leniency and a consideration for community service, which will include unpaid work for the benefit of the community. Further, in the pre-sentence report, although the beginning and the end of the report is contradictory, the court was persuaded to ignore the conclusion by the probation officer. It was also noted that the first convict comes from a polygamous family. He suffered several and many challenges. He lacked proper parental upbringing, and the environment became his family, and therefore, having suffered as such, his attitude and background would be diverse. It was also mentioned that poverty generates hopelessness and therefore a threat to someone's life. Having been orphaned at the age of 16 years old, it was stated that he had not gone a straight path to maneuver in life. The first convict was stated that the family mostly would depend on the community, and therefore much a challenge on his livelihood. The convict mother is said to be elderly and has been subjected into mental anguish by the conviction. Counsel for the first convict further reminded the court on judicial policy on sentencing. It is said that if the court proceeds to give non-custodial sentence, he stands to lose his mother, and the conviction has already subjected the family into suffering. His children have lost their father, and therefore they still continue to persuade the court to consider non-custodial sentence. The first convict has a certificate on community health and HIV management from MKU University, and therefore is an icon in the community. And for the 3 years he has been waiting for the trial, he has engaged into business of butchery and cattle selling. Through his lawyer, he is apologetic and therefore pleads with the court that the community is ready to take him up and integrate him, and therefore he would benefit from non-custodial sentence. It has been stated that he has carried himself with decorum and professionalism at Mama Lucy Kibaki Hospital. Out of his work, many mothers who are barren have gotten children, and children have gotten placements into family. It is stated that he has not been able to comprehend the gravity of the offense. Therefore, it was noted that he still needs time to digest and understand the offense. In summary, in regard to the second convict, he began by asking the court to exercise discretion in sentencing. She is a first offender. She is religious. She has religiously attended court and carried herself with decorum. She's a person of good reputation, and her neighbors were shocked on her conviction. She is passionate on hard work and hardworking. She has clean records at Mama Lucy Kibaki Hospital. She has always observed the code of ethics in the said institution. She's a reliable person in the community. She has carried charitable activities in kind. She's a mother of two minors, that is 8 and 12 years old. These 2 minors have always depended on her to prepare them to school and also assist in the demanding CBC curriculum. Her husband, who is a security officer, has had to leave his duties to attend to the children during the time pending sentencing. She lost her job, which she depended on to manage her family and also the extended family. She prays this court consider non-custodial sentence, and she will also need counseling guidance to address her psychological needs, since she's in self-denial, and the only remedy would be non-custodial sentence. The mother, the family has lost a mother, a daughter, a wife since conviction. In response by the prosecution, it was noted that the first convict has not demonstrated any remorse on the issues raised in mitigation and in the probation report. The prosecution team noted that the first convict is not remorseful. She has no empathy, and therefore he would need a deterrent sentence. The prosecution was also surprised how the first convict was not able to digest or comprehend the gravity of the offense, having been in court for the entire period of trial. And therefore, they are persuading with this court to give a deterrent sentence for him to comprehend the offense. The report by the probation officer was negative on non-custodial sentence in regard to the first convict. In regard to the second accused or convict, the courts, the prosecution appreciates that she was recommended for non-custodial sentence. She is also remorseful, and the prosecution invited this court to be the voice of the voiceless in regard to the 3 minors. I have considered and evaluated the mitigation submissions by the parties, the pre-sentence report by the probation officer. I have also been guided by the judiciary bail bonds policy, and I must mention that, as stated by the prosecution, as stated by all the parties, sentencing is a discretion of the courts, and I relied on one case among many others, the case of Francis Daramba. The Court of Appeal noted as follows: sentencing is a discretionary act of the trial court, even though the limits such as maximum sentence and in some cases the minimum sentence are prescribed by the law, nonetheless, is at the exact sentence to be pronounced upon conviction, upon a convicted person, the trial court has, in most criminal cases, the discretion to decide. The Judiciary Sentencing Policy Guidelines sets out 6 objectives of sentencing as follows: retribution, deterrence, rehabilitation, restorative justice, community protection, and denunciation. The judiciary policy also on sentencing goes ahead to put out issues of consideration when sentencing, and it is proper for the court before sentencing to consider aggravating circumstances surrounding any offense that would warrant a stiffer penalty that ordinarily would not have been imposed in the absence of the same. And I picked a few of aggravating circumstances for the court to consider in sentencing, and this would include where there are multiple victims, grave impact on national security, serious physical and psychological effect on the victim, targeting of vulnerable groups such as children, elderly persons, and persons with disability, intricate planning of an offense, and intention to commit a more serious offense than what actually committed, high level of profit from the offense, an attempt to conceal or dispose of evidence, abuse of position of trust and authority, use of grossly inhuman or degrading means in the commission of the offense. As I said, indeed, sentencing is an important task in a matter of crime as held in the Court of Appeal in Thomas Mambu Wenyi versus Republic, and also as quoted of the decision in the Supreme Court of India in Alistair Anthony versus State of Maharashtra. The court went further to state that one of the prime objectives of criminal law is imposition of appropriate, adequate, just, proportionate sentence commensurate with the nature and the gravity of the crime and the manner in which the crime was committed. Further, it must be appreciated that the common thread in sentencing is discretion of the trial court, but such discretion must be exercised judiciously and not capriciously. The first accused person was convicted of the offense of conspiracy to commit a felony, that is trafficking in person, further trafficking in person, and child neglect. The second accused or convict was convicted of offense of neglect of a child. At this point, I rested and asked myself, what are the issues? Are there issues or are there aggravating circumstances that would warrant a stiffer penalty than would be ordinarily imposed in their absence? There is no doubt that the offense included multiple victims, that is, children aged 8 days to 3 weeks. The offense of human trafficking is now an emerging trade and a transnational organized crime which has a grave impact on national security. The victims in the offense, who were minors, were exposed to abuse and human trafficking by the convicts, whose main role was to protect them. After exposure to trafficking, the victims suffered serious physical and psychological effects. One of the victims died after a few months. He was admitted at Imani Children's Home. As stated in the judgment, the first convict used legitimate transfer of victims, knowing that after they leave Mama Lucy Kibaki Hospital, no one would follow to ensure they arrived at Imani Children's Home. The first convict or accused targeted the vulnerability of the 3 voiceless minors. he was involved in intricate planning of the offense as demonstrated in various meetings between himself and the purported buyer, in quotes, Ross. As per the discussions in the BBC documentary, the first convict had all intentions to commit more serious offenses than would actually committed, or more serious offense than would actually commit. He went on to discuss of selling of one child, particularly baby boy, but gave out 2 other more in a legitimate baby transfer. He seemed to have indulged into high-level profits from the offense. He received 300,000 shillings from trafficking one victim. He even attempted to conceal or dispose of evidence by failing to update the children officer of the children admission and discharge at Mama Lucy Kibaki Hospital. The 2 convicts abused their position of trust and authority as medical social workers at Mama Lucy Kibaki Hospital, whose main call of duty is to protect vulnerable children among other duties. The first convict used grossly inhuman and degrading means in the commission of the offense of human trafficking and child neglect. Notably, the court is persuaded that the offenses under which the accused persons are facing the prescribed sentence, the word liable is used. The court was guided by the case of Daniel Chalo Mwema in the Court of Appeal, where it stated that the word shall be liable do not, in the ordinary meaning, require the imposition of the stated penalty, but merely express the stated penalty which would be imposed at the discretion of the court. In conclusion, I am satisfied that there are aggravating circumstances around the commission of the offense stated above. In sentencing, I have considered the mitigation by the defense as well. The convicts are first offenders. Although first convict apologized through his lawyer, it has been stated that he holds a diploma in medical social work and he has worked for several years. He ought to have appreciated the gravity of the offense. It is the finding of the court and the probation. It is the finding of the probation officer that he is not remorseful. He lacks empathy for others. It was noted that he was not truthful in his testimony, even for the obvious issues in the documentary, in the BBC documentary, and the same was noted by the probation officer. He is not likely to be rehabilitated in the community, and therefore he deserves a deterrent sentence owing to the aggravating circumstances surrounding the offense. And therefore, I would exercise my discretion and sentence the first accused or the first convict as follows. And the first convict will be sentenced to serve custodial sentence of 3 years on count 1 of conspiracy to commit a felony, that as a trafficking in person. In count 2, 3, and 4, the accused person will serve imprisonment of 30 years. In count 5, 6, and 7, he will serve a sentence of 2 years. The second convict, who is a first offender, will be sentenced to serve an uncustodial sentence, and the court will exercise discretion and give him a penalty of 100,000 shillings for 2 years imprisonment on each of the charge of child neglect. I wish to elaborate on the sentencing of the first convict. I wish to elaborate further on the sentencing of the first convict. Sentencing for each similar offense shall run together. Sentencing for each similar offense shall run together. That is, for count 2, 3, and 4, the 30 years will run together. For count 5, 6, and 7, the 2 years will run together. And further to that, the first convict is a first offender, and I will also exercise further discretion and say as follows. The first convict will serve 25 years in custody, 25 years in custody, and for purposes of reintegration back to the community. Out of the 35 years pronounced in his sentence, he will serve the remainder of 10 years under probation sentence, which will be he will be put under close supervision. Further to the sentence, I hereby order that for the period for the period of the sentence, the two convicts shall not be assigned duties related to children welfare. The two surviving victims are now available for legal adoption to enjoy a nuclear family setting. I also order the release of records produced in respect of the victims to the management of Imani Children's Home to facilitate adoption as the case might be. Each accused person or convict has 14 days right of appeal.